Hey, hello to people filing in. We're going to get started in a few minutes. Okay, looks like we are at critical mass here, so we can get started. Hello, everyone. Welcome to the California Law Review's 2020 Symposium, Democracy Reform for the 21st Century. So today we are going to get started with our first panel, panel one, which is our first principle, which is everyone has the right to cast an informed vote. I'm very excited for this panel today. We have some excellent speakers. My name is Benji Mailings. I am a 2L at Berkeley Law. My pronouns are he, him, his. I'm gonna turn everything over to our moderator and wonderful panelists forthwith. First, I'd like to let you all know we will be having a Q&A with about 20 minutes left, where you will be able to submit questions either anonymously or you can go ahead and ask them yourself and just indicate as much. And also just let you know this panel is being recorded and we will be sharing the symposium recording on our website. So thank you all, it's great to see you. I'm going to turn it over to our wonderful facilitator, Emily Rongzhong. Ms. Zhang is a PhD candidate in political science and an interdisciplinary graduate fellow of the Office of the Vice Provost for Graduate Education at Stanford. She received her JD from Stanford Law School in 2016. From 2017 to 2019, she worked as an attorney sponsored by the Skadden Foundation Fellowship at the Voting Rights Project of the American Civil Liberties Union, litigating voter suppression and redistricting cases in Kansas, Ohio, and New York. Her research mainly focuses on the protection of minority voters in the redistricting process and the enfranchisement of new voters. So I'm just going to turn it over to you, Emily, to help us introduce our panelists and to kick off the discussion. Thank you so much.
Thanks so much, Benji. It's so nice we're still able to gather for this event amidst the pandemic and now these really horrible fires. And many thanks to the California Law Review team and the Symposium team for making it happen. I hope everyone in attendance is doing, as well as can be expected under the circumstances. So the topic for our panel is a really pretty meaty principle. It embeds within it many wonderful things to aspire to: equality, a system that brings people in instead of keeps people out, and it has a vision of an informed electorate as well as a transparent system for voting. And what better way to see just how aspirational this principle is and how far reality is from those aspirations than by bringing together three panelists who know in all the micro and macro ways just how we're falling short of principle one. And you'll learn a little bit about what they do, and I'll have them introduce themselves, starting with Professor Gilda Daniels.
Well, good morning, right, and good afternoon in other parts of the world. I am Professor Gilda Daniels. I'm a professor at the University of Baltimore School of Law. I'm a former deputy chief in the DOJ Civil Rights Division voting section. I'm also the litigation director at Advancement Project's National Office. I have more than 2 decades of voting rights experience and work as a voting rights expert and consultant on many issues, and am the author of Uncounted: The Crisis of Voter Suppression in America, which was published by NYU Press this year.
Yeah, hopefully we'll get a chance to talk a little more about the book and some of what you discuss in the book throughout the panel as well. Michael?
Hi, everyone. My name is Michael Horse. I'm a PhD candidate in political science at Harvard. My symposium contribution, which also doubled as my PhD dissertation, evaluates the ballot initiative known as Amendment 4 to end lifetime disenfranchisement in Florida. And hopefully I'll get to talk about that throughout the panel.
Yes, definitely. And finally, Paul.
Hi, everybody. I'm Paul Smith. I have two jobs at the moment. I'm a professor for practice at Georgetown Law School, where I teach election law and constitutional law. And I'm, my spare time, vice president for litigation and strategy at Campaign Legal Center, which is in Washington, D.C., when we have a fairly broad portfolio of democracy protection and promotion work that we do, much of it litigation, some of it not, from campaign finance cases, trying to save the campaign finance system, to trying to fight gerrymandering and promote racial justice in districting. And this year, especially vote suppression. We're one of the main sets of lawyers involved in the Florida case that Mike was going to talk about people with felony convictions in their backgrounds and being able to vote after Amendment 4. And are just generally hoping we can contribute to getting this election done successfully.
Thanks for joining us, Paul. So I wanted to start the panel by the first word of the principle, because I think we're already falling short even at the very first word, everyone. Of course, we're far from a world in which everyone, and really everyone, is able to participate. And obviously our current reality isn't an accident. It comes from this troubled and troubling history that's premised on exclusion. And Professor Daniels' work is really on drawing out that connection explicitly between this history of exclusion and discrimination in voting and modern attempts to suppress voters. Professor Daniels, will you tell us a little bit about that work?
Well, I think it's important. So certainly, I think it's very important, particularly in the voting rights area, to always connect what's happening with historical occurrences, right? Because there is a connection, certainly, in how we have treated the right to vote historically in this country to what we're seeing contemporaneously. And we have always had a paradoxical democracy from the founding of this country, where we said all men are created equal. We at the same time said that that enslaved persons would be treated as three-fifths in regards to apportionment. So clearly attributing certainly second-class citizenship from the outset of the country, and only giving the right to vote to white men who own property. Was what we did as a country, certainly in the beginning, and by having this three-fifths compromise for the purposes of apportionment, certainly used race as a measure of value and determined the worthiness to participate as a full citizen, and the ability to participate as full citizens didn't occur for African-American men until certainly almost 100 years later, 100 years after we decided that all men were created equal, but treated them certainly unequally. And so with the passage of the 13th, 14th, and 15th Amendments, and particularly the 15th Amendment, which gave Black men the right to vote, we saw a glimpse of what democracy could look like. And we recognized that women could not vote at that time, but we saw Black men registering in number, registering and electing individuals on the state, local, and federal levels. And you saw it, like, for example, in places like Mississippi. Mississippi elected 2 African Americans to the United States Senate. We have not had 2 African Americans from the South elected to the United States Senate since the 1890s, since that occurred in the 1890s. We only have 3 African Americans in the United States Senate today. So from 1890 to 2020, you've only increased by a number of 1, right? And you had 2 African Americans from the same state. But it was that realization of the promise, right, of democracy and allowing African American men to vote, where we saw, what democracy could look like. But it was that threatened certainly white power and white supremacists and segregationists in the South. And that's when they forthwith began to implement laws that would eliminate essentially the Black vote, certainly in the early 1900s. And in places like Alabama, where you had approximately 140,000 Black men who were registered in 1890s, by 1906, there were only 46 Black men who were registered. So because of poll taxes, grandfather clauses, literacy tests, felon disenfranchisement, violence, economic terror, right, and the threat of death, those numbers diminished completely. The same thing happened in Louisiana and other parts of the South. And it would take almost another 100 years from the passage of the 15th Amendment to the Voting Rights Act in 1965, where you would again see, voter registration as well as the emergence, certainly of people of color in the voting rights booths. But you still had that period where you had certainly those disenfranchising devices were in place and were very, very effective. And while we saw them diminish somewhat during shortly after the passage of the Voting Rights Act, we have certainly seen them increase, certainly after the Shelby County versus Holder decision in 2013, and seeing voter purges, polling place closures, the restricted voter ID laws, and other laws that are causing the same effect that we saw certainly post-Reconstruction and certainly shortly after, before the passage of the Voting Rights Act.
Yeah, and I think the sort of vestiges of this very ugly history of racial exclusion in voting are kind of nowhere more apparent than in the case of felon disenfranchisement, which persists till today. And I'd like to turn to Michael and tell us about Amendment 4, because it's just really pretty much a situation of outrage upon outrage. Will you start us off on kind of how we got to Amendment 4 and then tell us about what's happened since?
Definitely. So how did we get to Amendment 4? I'd say some broad context is helpful. So in 2016, there were about 6 million people who could not vote in the United States because of a felony conviction. And my home state of Florida was a particular outlier. There were about 1.6 million people who could not vote because of a felony conviction. And the vast majority of these people, about maybe 1.4 or 1.5 million of them, had completed prison, probation, or parole if applicable. And so Amendment 4 focused on the state of Florida first because there are more people disenfranchised in Florida than anywhere else. Second, Florida, which practices lifetime, or at the then practiced lifetime disenfranchisement, would only restore your right to vote if you basically made a personal appeal to the governor of the state of Florida. You would head before an executive clemency board, which was chaired by the governor and 2 cabinet members. But during the entire tenure of Governor Scott, I believe the number of people restored the right to vote, it may be in the few thousands, it may be even less than that. Essentially, for a state with as many people as Florida, you had no hope to restore your right to vote through the process as it existed. And there were many times since the 2000 election up until Amendment 4 was on the ballot in 2018, where there were attempts at legislative reform in Florida. And essentially what ends up happening in that period and throughout the country is that there's this perception that the restoration of the right to vote to people with felony convictions will be a boon to the Democratic Party. And so the result is you see a lot of Republican legislators discussing their opposition to reform in terms of its expected partisan consequences. That happens all the time in Florida, particularly because the 2000 election was so close. That was kind of primed. And so Amendment 4 takes an alternative route. It didn't work before to challenge the statute in the courts. It didn't work to go to the state legislature. It didn't work to use executive reform. So they had a ballot initiative and they went to the people. And I think one of the most amazing things about Amendment 4 is the hurdle was really high you had to get 60% of the vote in order to pass a ballot initiative and amend the state constitution. And they did that. And a key kind of insight that the campaign had, and that goes to this theme about who is unable to vote, that everyone does not include everyone, is the campaign kind of realized that there are all sorts of people who cannot vote because of a felony conviction. And they ran a very inclusive campaign. It was focused primarily on this concept of redemption. And importantly, in order to pass a constitutional amendment, and they had to get 60% of the vote, you needed Republican support. And so a lot of my work is I collected all of the ballots cast in the state of Florida, and I can see, oh, this person cast a vote for Ron DeSantis. They're a Republican. How many of those people voted for Amendment 4? 40%. And they were most successful at capturing Republicans in poorer areas and more diverse areas. And I think that's a real testament to kind of this new idea of how to run this type of campaign. So my work, that's kind of how we got to where we currently are with Amendment 4. And I think now, I think this may be something Paul discusses, but the interpretation of what was actually passed is now under huge scrutiny and currently tied up in the courts. I'm happy to talk about that, but I don't want to go on for too long.
Yeah, Paul, since CLC is involved in the litigation, will you tell us a little bit about the sort of litigation in response to the passage of Amendment 4?
Well, what happened after the amendment passed is that people focused on the fact that essentially everybody with a felony conviction in Florida ends up owing fees and costs, sometimes fines and restitutions as well. They fund the court system out of charging fees to people who find their way into the criminal justice system. Of course, there are fines as well. And the large majority of the people who were given the right to vote back by Amendment 4 can't afford to pay off the fines and fees that they owe. And so the question then was, can they vote? The amendment said you have to complete the terms of your sentence. And first the legislature and then the Florida Supreme Court both said terms of the sentence includes all fines, fees, and costs. And so the litigation started by arguing that if you have two people identically situated, except one has completed his sentence because he could afford to pay the fees and costs and the other can't, that's wealth discrimination. We also argue that it's a poll tax, and that there's also a due process argument because the state of Florida is so messed up in its record keeping that it can't even tell people what they owe and what they've paid. And so the combination of those three things persuaded a federal judge, Judge Hinkle, to say that Florida can't bar people from voting based on the fines and fees requirements. That was unfortunately stayed by the en banc 11th Circuit, where we argued the case a couple of weeks ago. And so we're waiting to see whether we may have persuaded half of the en banc court to let the decision go into effect. It was an interesting argument that looked like we might have a shot. You want me to talk a little bit about purges at this point, Emily? Is that the
yeah, I wondered if, after sort of talking about felon dis, which is, so connected to the history, we'd maybe talk about an example of sort of modern voter suppression and what that looks like.
Well, one of the ways in which some states do try to trim the electorate, often I think because they think it'll be advantageous to certain interests, probably Republican interests, is in the way that they purge people from the voting rolls, cancel their registrations. Now, canceling these registrations per se is not a problem. The states have a duty under federal law to try to maintain current and accurate rolls so that when people die and they get notice of that, they should be stricken from the rolls. When people move to other states, they should be stricken from the rolls. And so they're in the process of doing that sort of relatively continuously. But the same federal law that says they should be doing some of that to try to keep their rolls up to date also provides various protections from purges that are done abusively. And the one key principle that Congress said in the National Voter Registration Act is that you cannot be purged for failing to vote. That is, you have a right in this country to choose not to vote as a registered voter and maintain your voter registration. It also specifies the reasons why you can be purged, one of which is if you've moved to another county or state. If the state is going to purge you based on the supposition that you have moved to someplace else, the statute says that the state has to go through what's called the confirmation process. They have to send you a notice asking you to return it, telling them where you are and what you're up to. If you don't return it, as most people don't, the state then has to wait 4 years before it can throw you off the voting rolls. And so what Ohio did, Ohio was the defendant in the Husted case I argued in the Supreme Court a couple of years ago. It was a state where they used to have this use it or lose it kind of policy. If you don't vote, you're not going to stay on the rolls. And they came about as close as they could to maintaining that approach, trying to make it consistent with the National Voter Registration Act. So they adopted the assumption that anybody who doesn't vote for 2 years probably has moved to another county or state, an assumption which is essentially preposterous on its face, since that means that any non-voting in an off-year election, non-presidential election, can get you into this category of people who are suspected of having moved away. And based only on that, even though in some years that might mean 70% of the electorate is suspected of moving, far more than is in all likely, they then triggered this confirmation process. So if you don't vote for 2 years, you get the notice that says, tell us where you are. 75% of the people who get that throw it in the trash. The state waits 4 more years and you get purged. So essentially what they've adopted is a policy that says if you don't vote for 6 years and you fail to return 1 notice, you are off the rolls, despite the fact that non-voting isn't supposed to be a basis for purging people. So the ACLU and Demos brought this challenge to that and said there has to be some rational trigger that said before they send you this notice and put you into the confirmation process, they have to have some good reason to think you've moved, like you filed a change of address with the post office, or they've been sending you mail, it's coming back undeliverable, no longer there, something like that. But not voting for 2 years is just not an indication at all that you've moved, and a process set up that way is essentially certain to purge hundreds of thousands of people who haven't moved and are eligible to stay on the rolls. They simply haven't been voting recently. And we saw this phenomenon in Ohio in 2008. An enormous number of relatively infrequent voters were energized to come vote for President Obama, and they found out they weren't registered voters anymore, much to their surprise. So issue goes up to the Supreme Court. The Supreme Court splits 5-4 along the predictable lines, with the majority saying the statute does not require Ohio to have any kind of rational basis for initiating this process and for treating you as if you had moved or suspecting you've moved. They can have any trigger they want, as long as they go through that confirmation process. You get your 1 letter, they wait 4 years. If you don't vote, you're out. And that statute, so interpreted, is of course really completely inconsistent with the underlying principle that people should be able to choose not to vote when they don't feel like it, secure in the knowledge they can stay registered, because essentially what happens is 6 years of non-voting and missing 1 letter and you're out. So it's an unfortunate decision. It could be fixed statutorily, happily, and we're going to talk later, I think, about HR 1. That's one of the things that HR 1 would fix.
Yeah, and I'm sure folks are interested in sort of what's happening in November, and obviously, you know, what you and Michael have described that's sort of leading up to this particular election. I wonder if Professor Daniels, you can tell us a little bit about sort of specific challenges that we're going to face in November, the militarization issue, and, you know, the prospect of voter intimidation being, you know, perhaps scarier in November than we've seen recently.
Well, we have a few things happening, right? Certainly with the COVID-19 and the ability to cast a ballot freely and safely. And one of the remedies for that is to expand and increase vote by mail opportunities, certainly in states where they have restrictions. But we are certainly seeing there's been considerable pushback as well as litigation on that issue. I think I told you I'm the litigation director at Advancement Project. We filed a lawsuit in Florida before the presidential preference primary, because students and citizens, certainly in Florida, the students were being told to leave the campus like 4 days before the presidential preference primary, as well as they were people who were concerned about this, the state of emergency, right? There was a state of emergency declared shortly before the presidential primary in Florida. And what we filed a lawsuit saying that the state of Florida needed to expand early voting, increase the cure period, meaning the period where if there was a problem with a vote by mail, with an absentee ballot, that the person had more than 2 days to correct, to verify that they were indeed the person who sent in the ballot, as well as with we also had claims in regards to the state's online voter registration system. With COVID, voter registration, and we in the discovery phase, we learned from some of the supervisors of elections that their voter registration levels had hit zero, that 0 persons were registering because they didn't have the ability to, right? Because everything was closed, everything was shut down for a considerable period of time. And so, saying to Florida that you need to expand early voting, you need to expand early voting, you need to expand absentee balloting, you need to do all of these things in order to ensure that people are actually able to vote. And it's important to know the CDC has said that these are the kinds of things that need to happen to expand absentee balloting, expand early voting, and to ensure that proper safety protocols are carried out for those persons who choose to vote in person. There's certainly in regards to vote by mail, and it's important to note that it will cause a cultural shift, right? And that there's going to be a great need for education on vote by mail if it's going to be used as in the widespread manner that we certainly think that it will be in this coming election, because in states like Florida, Black and brown voters have a higher rejection rate of their vote by mail ballots. And so when we're telling people to vote by mail, we need to make sure that we're telling them to do a few things, which is to make sure that they're following all the instructions, that they have a consistent signature, because most people's ballots are rejected because of signature mismatch, because they're looking at the signature that you use when you did your driver's license, right? And so those kinds of issues are certainly going to impact whether or not people are actually able to vote, as well as voter intimidation and misinformation, because there's a lot of misinformation out there. And you have the president telling people to vote twice, but please do not vote twice. That is a felony. All right, and you cannot. And there are other things that the threat to deploy the military to the voting to polling places is certainly, this is a high level voter intimidation, but it's also not new, right? We've seen this before, certainly with Bull Connor standing in the courthouse door, arresting people and beating people for trying to register to vote, right? And then so you see this militarization is certainly something that we need to be aware of, which will certainly can serve as an impediment to people actually accessing the right to vote. And it's important that people know that, this is another aspect of not having Section 5, or certainly that Section 4 was deemed unconstitutional, in that we used to have a federal observer program where you would have federal employees dispatched throughout the United States, and certainly in contentious places. And so now, without in the Shelby County decision, essentially got rid of that aspect of the Voting Rights Act, and so not having federal observers and having the threat of police and the military at the polls certainly serves as an impediment. And we have to consider where do we tell people to go, right, in order to ensure that they are safe. It's certainly a public safety issue, but people also have to be equipped to know, that they can, who they can call when they see these kinds of, see these kinds of activities, and what needs to be done. And I think we're going to talk about that a little later.
Yeah, I wanted to now sort of ask Michael about, sort of voter ID laws and voter purges, these things we've heard in the conversation for a while, how they're likely to impact, November and beyond.
Sure. I definitely want to address that. I just wanted to add one thing, though, on Amendment 4, just to provide context for what Paul said, which is when we're thinking about kind of what are the obstacles that people are going to face, at least in Florida currently, the primary obstacle is that the vast majority of people with a felony conviction are now too poor to vote. So you're talking hundreds of thousands of people who owe in my data. So what I did is I collected court records throughout the state of Florida, very similar to what the expert did as part of that case for individual people with felony convictions, and kind of went through to estimate how much they owe in fines and fees, how much they've paid back, things like that, just to give the audience a sense, because I think these numbers are not what people expect. A typical felony case is resulting in about $800 in fines and fees. And because someone may have multiple cases, the typical individual is facing a bill of more than $1,000. So I think that's just helpful context in just trying to understand the primary obstacle, I would say, is a financial obstacle. But to go to voter purging, one of the things that I have been focused on now, and I think that also ties in with what Paul was saying, is that the system that states and counties have used in order to engage in list maintenance relies really on this idea that a postcard notification works in order to correct errors in the process. So, if you want to give the counties or the states the benefit of the doubt, they do their best to identify people who aren't currently eligible to vote at their address of registration. But there are plenty of problems with the processes that they use. And one way to find any errors in that process is that they can mail people a postcard saying, "Do you still live here?" And some of the new work I've done in Wisconsin is through public records requests. We got the names of every individual who was mailed something saying, "Do you still live here?" And because of a quirk, the people who did not respond actually were not removed from the roll. So we can track their behavior over time and show that a not insignificant number of people who did not respond to a postcard actually live there and actually vote. And I do think that is going to be kind of an obstacle, which is that the postal notification is not the fail-safe that I think we may hope or think that it currently is. And as to your question about voter ID laws, Emily, I know you also have done empirical work on voter ID laws. I think I come at it more as a social scientist than as a lawyer. In this case, I think the pressing question to me is misinformation and confusion. When I have looked at the data among people who show up to the polls and want to vote, but don't have ID, that very narrow but precisely defined causal question, there's not much evidence there. But you do see that a lot of people who live in a state that you don't need ID to vote think you need ID to vote. And there's a lot of other pathways in which the population can, because the laws increasingly get confusing, they change by state, within state, certain types of IDs are allowed and not allowed. That itself could be demobilizing. So I think I'm most concerned on that side just about confusion, not necessarily the substantive state law, or at least primarily about confusion at this point.
Yeah, and I think what we've sort of really covered is this kind of web of this very entangled web of things that make it difficult, confusing, misleading about whether you have the right to vote. And that's sort of all coming together. And what Michael in particular identified is the sort of interjurisdictional transference of fear, intimidation, and misinformation. So I think Michael's work sort of showed that even in places where the laws are pretty liberal, we've got these laws that are not so bad for people to vote in. Voters still expect worse laws because of what they're hearing from the news or their expectations about how bad the situation is likely to be. There's so much to talk about when it comes to how things are bad, but I do want to make time to talk about how things might get better. And it's hard to feel that way sort of, you know, when you're breathing purple air, but I think that is something that we should sort of turn to. Paul, do you want to tell us a little bit more about HR 1, which you've kind of alluded to already?
I will do that, but let me just interject that my phone just lit up about 4 minutes ago that the 11th Circuit ruled in the Florida felon case. Judge Pryor reversed everything, so it looks terrible.
Reversed?
Yeah, said there was no constitutional violation proven.
Are you kidding?
Well, I haven't read it, but that's what it seems to say, yeah.
Oh, wow.
A discouraging day for
Yeah.
hundreds and hundreds of thousands of people in Florida who would otherwise be able to vote this year. But trying to be cheerful, as Emily asked us to be.
Oh my goodness.
One of the things that we know is that there's no reason why we have to have such an incredibly antiquated, unfair voting system in this country. HR 1 is a piece of legislation which passed the House last year and is pretty likely to pass the Congress in some form next year if the Democrats control both houses of the Congress. And it has a whole lot of stuff in it, from redistricting reform, independent commissions, to campaign finance reform, public financing of congressional races, and all of that. But in terms of voting, what it does is it tries to fix the most obvious flaws in our system. It shouldn't be difficult to be registered. That one of the greatest barriers to voting is people just aren't registered. So it would provide for all the states to have both automatic registration, same-day registration, online registration, all of the things that any modern system would have if you really want everybody who's eligible to vote to be able to vote. It has a pilot program to help of starting to bring registration information into the high schools so that people, when they're 17, can start getting ready to participate in the process. And there's a whole bunch of other stuff in there about poll worker recruitment and making sure that every vote has a paper record so we can be sure how to count it and what was intended. A lot of improvements in election administration. It would make a transformative difference in voting in this country if it were passed and enforced. And as I say, one of the things it does is it fixes the Husted purge problem. It says that not voting, not returning that card cannot be considered evidence of a basis to take you off the voting rolls. They have to have affirmative reason to believe you've moved to a different jurisdiction, like you posted a forwarding address or your mail's coming back undeliverable. In the absence of that, you're entitled to stay on the rolls. And you know, just following up what Michael said, the study we did of this issue in Georgia, in a case down there, suggested that most of the people who are being purged for non-voting have not moved. You know, it's remarkable that states are indulging in this assumption, given the realities of how many people just vote infrequently. But I think I'll pass it back to you, Emily.
Yeah, well, maybe, you know, since we're, I wanted to ask Michael, you know, whether there are good things states can do with regard to, you know, rights restoration for individuals with criminal convictions.
Definitely. I was a little distracted because after Paul said that, I was quickly trying to find this opinion. I have located it, but it's 200 pages. I'm not going to attempt to know what it said. I think that there is things that people can do. So I think one of I think Amendment 4, when I focus on that, it was a focus on a restriction on the right to vote, but there are more people with felony convictions who are legally eligible to vote than those who are ineligible to vote. And so confusion is really a theme here. Trying to, I mean, there it's helpful. You don't need to necessarily pass all these laws and change the Constitution and do all of these things. So some of the work that I've done is I've evaluated state efforts to inform people that they are eligible to vote. And this is very important when, for a period of time, you are legally ineligible to vote and the state is enforcing that restriction against you under the threat of a felony. So in Iowa, one thing that I did, and this actually came back now, I think maybe in the news in the last 2 weeks, is about 10 years ago, Iowa passed the governor of Iowa signed an executive order, and the governor restored the right to vote to a lot of people with felony convictions in the state. And one of the things that they did that was very helpful from a social science perspective is that they mailed the executive order, which informed people that they had the right to vote, to some people, but not to others. And for purposes of this, I won't explain exactly why they did it for some and for others, but the benefit of that approach is we were able to compare those two groups of people and see that there was quite a significant effect of the group. Both groups were eligible to vote. Both groups had been restored the right to vote. But the group that had this more or less official communication from the governor showing that they can vote, their turnout, their registration really increased. An interesting and important thing though in all of this is implementation matters. And so when we then looked at a few other states, we looked at New York, New Mexico, and North Carolina. They also had passed a law, or as a result of a case, were required to inform people upon exit from prison that you were legally eligible to vote again. And you don't see any effect. But when we look into it, you see that everyone got an exit packet of some sort. And there were many pieces of paper in that packet. And one paper among them all was an informational thing about the right to vote that was not very easy to understand. And so I think in all of this, it's like there is a promise and a potential if we do it the right way, but implementation is really important. And I hope that that is something that kind of the empirical law community can collaborate with county officials and with state officials to say, when you inform people, you should, there is a set of best practices, there is a way to work. And I think I'm hopeful that that's something that can be done in the future in more places. It applies just as much to voter identification schemes as it does to felon disenfranchisement schemes. And I think that's something I have to keep trying to pursue, trying to push informational awareness and interventions.
Yeah, and this also speaks to a role sort of for advocacy groups and for other sort of non-governmental actors to fill the void in states where you don't see those actions. Professor Daniels, will you sort of, maybe close us out by talking about kind of the reforms you see that are, on the table, not on the table, but really needed? What can we do to fix things?
Well, I think, certainly as Paul was saying, congressional action is certainly needed and something that needs to be considered not only with H.R. 1, but also Senators Warren and Durbin actually proposed a right to vote amendment that would have an explicit right to vote in the United States Constitution. So that's also legislation that needs to be considered. And I think we've been talking about Amendment 4, and I think one of the things that is very important in regards to encourage, that isn't something that is encouraging and something that is hopeful, is that Amendment 4 only happened because there were people on the ground who said, we need to change this, right? It really was a grassroots effort. It was really a miraculous and wonderful display of people power right? And the power of the people banding together to try to effectuate change. And they certainly did that, right? In overcoming the odds, in getting the ballot initiative first on the ballot, getting the initiative on the ballot was the first hurdle. And then to get more than 64% of Floridians to vote in favor of it, right? And then, and then you see this, when you see the legislature say, and I have a subtitle of my book, which is "Free at Last, Not So Fast." So essentially the legislature said, "Free at last, not so fast." It's like, yes, this amendment says you now have the right to vote, but not before you pay your fines, fees, and restitution. And so just certainly an example of certainly voter suppression and the way laws are used, right, to suppress the vote. But and what we're seeing on the ground is certainly, as Michael said, it's not just that these laws are in place. And even when you are able to achieve restoration, right, to restore the right to vote, it's in the implementation, right? We're seeing that in Louisiana. We're working in Louisiana with Voice of the Experienced, an organization in Vote, the organization Vote, on that issue, on this issue as well as we saw it. Certainly executive action certainly has worked in other places, but certainly implementation is where we need to focus. And it's not just confusion around felon disenfranchisement, but it's certainly the lack of education. And that we need to have more voter education, which is one of the things that we got we actually settled the Florida case, and that's one of the things that we got for the people of Florida, that the Secretary of State has to educate and educate the supervisors of elections, as well as provide educational materials throughout the state. So so there are certainly congressional reforms. There are reforms on the state level, but a lot of this work is going to be done on the grassroots level, right? We know that the courts are telling us, certainly for redistricting purposes, right? The cases coming down from the Supreme Court, even from the Husted case to may soon be Jones versus DeSantis in the Amendment 4 case, and in the Rucho versus Common Cause case that dealt with partisan redistricting, where the Supreme Court is saying we're not open for business. And so you're seeing a lot of work being done on the state level and with state laws, which will be the place where we'll have to look in regards to voter intimidation and voter deception, because the state laws are so much better. And the federal laws, certainly the Voting Rights Act, it is the federal government that would have to bring the case, and it's to the extent that we certainly lack trust in whether or not those cases would be brought. Certainly leaves us pause. But I ask people to do a few things, and it's educate, legislate, litigate, participate. Educate yourselves and others about the process of voting, about deadlines, about registration deadlines, how to vote, when to vote. So we have to educate ourselves, as well as mandating and requiring that the election officials do the same. And legislate, being aware of what legislative measures are being imposed or certainly being recommended. And so knowing about HR 1, knowing about the right to vote amendment is something that everyone has to do. And litigating and working with organizations like Campaign Legal Center, Advancement Project, NAACP, LDF, Lawyers Committee, Demos, Latino Justice, and others, when that tool is needed. And then finally participate. Everybody's got to participate. Like, again, we would not have had Amendment 4 if it wasn't for people saying this needs to change, and it's going to take that kind of effort, that kind of relentless effort for us to see changes, certainly in November.
So I'm seeing a lot of questions flow in, but I'd like to give Michael and Paul, if you have anything you'd like to close on before I turn to Q&A.
I have to say, I think that Gilda did a perfectly good job of closing us out, and we should probably get to the questions, unless Michael wants to weigh in.
That sounds good to me. I just wanted to emphasize that I thought it was great that it was an important part of education is not just educating the people, but educating county election officials. I've definitely routinely found that even though you're not misstating the law, you're not explaining it in a clear enough way that someone can act on that. And I think that's critical. Well, with that, I'm ready.
Great. Okay. Thank you all so much. This was really interesting. And thank you all for carrying on while clearly very impactful news broke in the middle of this. And as you might expect, actually, a good deal of our original questions do relate to this Jones v. DeSantis decision that just came down. Obviously, no one has read the 200 pages, but I think nonetheless, a lot of attendees here do kind of naturally feel both, you know, anxiety about the future, but also sort of energy about sort of immediate risk. In paying for generally. And so I'm just wondering, I guess, if specifically about any immediate responses. Sorry, it's because my internet is unstable. Hopefully you can hear me.
Benji, you might want to repeat that because you cut out at some crucial parts. Sorry about that.
I'm so sorry. I'm so sorry about that. I have a third grade teacher roommate at home, so I might be presuming. So, well, basically, I just want to ask, I mean, we have a lot of anxieties about the immediate response to this 11th Circuit.
Uh-oh, I'm going to take over for Benji. I'm so sorry. Uh-oh, you're cut.
Oh, I'm so sorry. Okay.
I'm just going to paraphrase for you because I know where you're going. Does anybody want to weigh in on the 11th Circuit opinion and where we go from here? I mean, again, clarifying that no one has read it.
Right. Well, obviously, there's two places you can go. One is you can go to the Supreme Court, which may or may not be a place in which there's going to be a lot of relief. We may very well decide to try that. The other is you can help people pay their fines and fees. A lot of them are very small, relatively small. They're a lot for the people involved, but there have been a number of people trying to organize efforts to raise funds to pay it off. And there is no reason why the money has to come out of the account of the individual involved. If people want to try to help people pay their fines and fees, they can make an enormously significant contribution to people's ability to vote if they can do that. So some of those efforts are underway. LeBron James has been involved and others.
I think one thing that I would add to that is I think systemic change, though, as what we're seeing here, just is going to require addressing the criminalization of poverty. So it is true, and it is amazing of LeBron James to pitch in and organize and attempt to pay the fines and fees of some individuals. But fines and fees are enormous. There's a lot of people, and the system, the courts are self-funding on the backs of people who are poor. And so I think one thing that is going to have to happen is we're going to have to shift our focus and our advocacy campaigns to make people more aware of this and to try to, at its root, redirect the fines and fees and reform fines and fees separate and apart from the fact that now fines and fees are being tied to the franchise, which they shouldn't be. But I think that is one other type of reaction that people may have, and that would be very productive. It's kind of going to combine election law and criminal justice reform, and how if you advance criminal justice reform, you may be helping election law or the right to vote, things like that.
Couldn't agree more, Michael.
Right. And using all the tools, right? Legislative, policy, you got to do campaigns, public policy campaigns, as well as litigation. And I think, you know, what Paul and Michael are saying, I think we can do both. We can all help pay folks fines, fees, and restitution so that they're I think LeBron James's program has seeded like $100,000, and if the average, if they're of the 770,000 people who are being disenfranchised, if there are 100,000 of those that are $1,000, and that's 100,000 people who can vote. But that's only if the state of Florida has correctly indicated how much money they owe, which we know that's a part of the problem as well. But yes, and Michael, we've seen when you try to put the criminal justice system on trial in a felon disenfranchisement case, you don't win. That was Farrakhan versus Gregor. And so we have to use all the tools that are available to us, including paying off fines and fees, which organizations, certainly FRC and other organizations certainly have been pursuing for quite some time, as well as litigation and public policy and reform.
Nevertheless, it's a very frustrating day because it seemed like we had a really well-reasoned opinion from the district court. The evidence was extremely clear that this was a huge burden on people's rights, and they're raising the money for the court system with these fees. They're classic taxes, but when you tie them to voting, they become poll taxes, and that's illegal under the 24th Amendment. But apparently that was not persuasive to more than half of the judges of the 11th Circuit.
And Paul, we're using this, I'm teaching appellate advocacy this semester, and we're using the Jones v. DeSantis case in our case, so I have to call you so you can. Maybe we can help.
I've been on Zoom, as you may recall.
Yeah. I think there's a lot of energy and a lot of concern right now coming from Florida. So thank you all for that kind of specific, targeted guidance. I think we also have some questions that are more concerned with sort of, I would call big S structural changes. And by that, I mean, we have a question asking about, does this all end in needing a constitutional amendment? I mean, is this just sort of a judicial and partisan back and forth until we can, actually, etch something in the Constitution? And I think similar to that, someone asked about moving our electoral system to something that we see in Australia, like reframing voting as an obligation, making it mandatory. So I'm just wondering what your responses are to those sort of big kind of really changing the structure of voting, putting it in our Constitution, making it an obligation, what you respond to those kind of proposals, and anyone could jump in.
Well, I talk about both of those things in the book. One having compulsory voting, as well as whether or not a right to vote amendment is necessary. I had, compulsory voting. In Australia, you have to pay a fine if you don't vote. I think it's like a $50 fine or something of that sort. And so, whether or not it would work in America or something that we should do, I think it's certainly something we can talk about, because we're talking about, how do we have essentially increasing participation? But that's operating from the premise that people actually, that we want people to participate. And I think when we see all the impediments and barriers that are placed in front of the right to vote, then it certainly makes you question if you really are, as Justice Ginsburg said in the Crawford versus Marion case, if we really wanted people to vote, then why are we making it harder, right? And so compulsory voting is certainly something that you do if we really wanted people to exercise the right to vote. And I think in regards to a right to vote amendment, I mentioned the 15th Amendment and the 19th Amendment, and I use in my book, I use my grandmother as a type of framework. She lived to be 99 years old. She died last year, but she was born in 1919, which was the year before women got the right to vote. So so women got the right to vote, in 1920, we celebrated 100 years of the right to vote for women. My grandmother didn't vote for the first time until the 1960s. Right? So you had a constitutional amendment that said women should have the right to vote, yet by virtue of her being an African-American woman living in the South, she did not have the opportunity to cast a ballot until the passage of the Voting Rights Act, right? And it was because of those literacy tests, economic terror, violence, poll taxes, and other measures that stopped her from going to the ballot. And just having a constitutional amendment certainly we have seen that that is not enough, right? Because with the 15th Amendment and then the 19th Amendment, that was not enough to ensure that all people had the right to vote. And so I think if we're going to have a right to vote amendment, that it has to be more in line with something with, like, for example, the Second Amendment. You know, one of the quotes in the book is in regards to the voter purge. The gentleman said, I don't lose my right to vote. I said, I don't lose my right to own a gun if I don't buy a gun. Why do I lose my right to vote if I don't vote? Right? And so, yeah, so do you need a right to, so have a right to amendment, a right to, just as you have an amendment that says you have the right to bear arms, maybe we had a right to, an amendment that said you have the right to vote. that at least makes it more difficult and harder for, you know, these legislatures to pass these laws that is definitely making it harder for people to cast out.
You know, I would say that given the difficulty of passing a constitutional amendment in our polarized country right now involving anything relating to democracy, the focus ought to be on Congress. If Congress can be back in the hands of the Democrats, even by one vote in the Senate, there's an awful lot that could be done. In H.R. 1, as we've talked about, there's also H.R. 4, which would restore the pre-clearance regime of the Voting Rights Act, which is a truly important aspect of what's happened in the last 10 years in this country. And there are other things that could be done that Congress can do to make the system work better. Prohibiting discrimination of various sorts there is every reason to think that we can marshal a majority of people in this country who believe in participation if we can just get the politics right and start moving these things at the federal level. History would tell you the one thing that's not a solution is relying only on states, because there's always going to be the states that don't want to have people voting and would rather have people prevented from voting. And those are the most important places to get remedies. And typically it's the southern states, but it's not only the southern states.
Great.
In responding to the compulsory voting point, I just want to say, you know, there's something that's kind of a middle, less harsh than compulsory voting, which would be a national holiday that conveys the kind of social desirability of voting and participation without penalizing anyone.
Yeah, I mean, I personally think that compulsory voting is just un-American. It's contrary to basic First Amendment values of not having compelled speech. When I was arguing Husted, I told the Chief Justice I didn't think that was constitutional. I don't know why he asked me about it, but he did. Obviously you could pass an amendment, but it would be a pretty dramatic change in the way individual Americans maintain choices about what to do. I agree, we should just make it as easy as possible and let people exercise their own free will.
Great. And I guess I want to pivot maybe to the other side of the coin, since so many of you on this panel are litigators and are active in these court decisions, and we may not always get sort of the political change.
But Benji, I'm retired.
That's yeah, have litigated. So we have this question that I feel is really on point for some of your expertise, which is someone asked, you know, given the politicization of the judiciary, which itself has politicized voting rights, is what they say, you know, where do we go from here? And I assume that question is just sort of gesturing towards, you know, separate from, and of course, knowing that these are always, of course, paired, what is sort of the horizon of, you know, litigation, of strategies for navigating the judiciary?
I think we're looking at a time period, even if progressive pro-participation policies start getting promoted at the federal level of the legislative branch and the executive branch, where the judiciary may continue to try to use the Constitution to cut back on voting. Shelby County is sort of the classic example of it, but there are other things that a Roberts Court might try to do, and you know, there's other parts of the Voting Rights Act that I think are at risk in the Roberts Court already. And then if Congress starts passing more things requiring states to open up their voting systems, the conservative justices may push back. We could have a kind of reprise of what happened in the 1930s when the New Deal was being taken apart case by case by a conservative Supreme Court until they finally stop doing that. It'll be an interesting political time if the court remains in the hands of conservatives and if the rest of the government changes hands.
I'll say for the litigators in the room, you know, there are different venues to bring these cases in. You know, going to the state courts is yeah, you know, you still get to litigate. You still, you know, you're able to get some change in the partisan gerrymandering area, for instance. North Carolina and Pennsylvania are places where you can bring those cases even if you can in federal court. And I know that, for instance, certain rights restoration cases for individuals with criminal convictions have been brought in state courts in the hopes that they'll be more successful there. So there is, I think, still a place for litigation. Unfortunately, federal litigation, you know, may not be that successful.
I mean, there's a downside to the state courts as well, which is unlike in Pennsylvania and North Carolina. Many of the state Supreme Courts are elected, and I mean, are not only elected, but are politically aligned with the majority running the state. And so it is, you know, I'm doing cases now in Georgia and places like that. Nobody thinks we should be up in the Supreme Court of Georgia and on voting rights issues. So it is a mixed bag in the long run.
Well, I can also, you know, Benji, the revolution will not be litigated.
Yeah.
So, you know, it's a tool that we can use, and you know, it's just one of many tools that that we can use. But you know, I think certainly that we may have had an over reliance, particularly on the federal courts, in the last certainly 30, 40 years, and we are certainly seeing that pendulum swing in the opposite direction. So you know, the revolution will not be litigated. We do have to be more strategic in the kinds of cases that we bring and appeal, right? Knowing that these courts are certainly in certain circuits as well as in certain states would be less favorable to the positions that we want to forward.
Great. I think we have time for perhaps one last question. I did want to flag this interesting question that I don't know if is within the ambit of any panelists here, but someone was really interested in the connection between immigrant rights and paths to immigrant citizenship with voting rights. And I imagine that question sort of goes back to the question that started this panel, that is, who is everyone? I mean, who is the electorate and who are we sort of looking to grant citizenship and the duties that come within? How are we navigating that? So I'm just curious, this person just wants to know of any efforts or groups or even, I guess, principles to guide one in sort of combining those kinds of areas of work. So if anything comes to mind. It's okay.
Yes. So I know the Advancement Project has an immigrant justice project as well as a Power and Democracy project. So Advancement Project is certainly a place to go. MALDEF, of course, Mexican American Legal Defense and Education Fund, Latino Justice, PEARLDEF, which is the Latino Justice Puerto Rican Legal Defense and Education Fund, also works on certainly immigrant issues and in their connection to voting rights. So that those are a few places to start.
I would just say that we're in a place, you know, a very troubling time where, you know, hostility towards non-citizens is really merging with the voting issue. The prospect of non-citizen voting is brought out as this unbelievably horrible specter, when in fact, you know, we've got some non-citizens on the voting rolls, but very few of them do actually vote fraudulently. And that's become this boogeyman, and that's been very unfortunate.
Okay, so also, I'm gonna add this last thing. So I live in Maryland, and we have in Tacoma Park, Maryland, you can vote in local elections if you are a resident. You do not have to be a citizen. You can also vote in those local elections if you were previously convicted of a felony, right? So, you know, Tacoma Park might actually be the utopia, right, for voting rights. So there are things that we, you know, that can be done and that we can do in that regard, and certainly things that we should do to expand the right to vote.
Okay, well, unfortunately, I think that is pretty much all the time we can have without going over. I think I just want to thank you, especially our facilitator, Ms. Zhang, and also our panelists for this great conversation, and also a fascinating one where we got to respond to some troubling breaking news, but that doesn't happen at every academic panel. So I appreciate your willingness to sort of stay on with us and react in real time and let us see how you think through these, really complicated, evolving issues. So thank you so much. And I'm sure you're eager to log off and start reading this 200-page opinion. And thank you to the audience for your great questions and for participating in this conversation. So there are, of course, this is just the first panel in our symposium. So if you're interested in more, please do visit bit.ly/CLR Symposium 2020. Then you'll be able to learn about and register for our next panels that go throughout the next few days. And also please feel free to follow the conversation at Twitter. Our social media will be following along as well with the symposium at #CLRDemocracyReform. And with that being said, yes, Michael, do you have something? Oh, I think we have
Can I just add one thing before and Paul too, before
yes.
we sign off, which is just, it is crazy to be on this panel as the Amendment 4 case comes out. It's very dispiriting. But for the audience members and people who are a little hesitant, in Florida, there was a case where pretty similar, they attacked the statute as discriminatory. The 11th Circuit panel was good. They went en banc and they reversed it. It was dispiriting. But Amendment 4 as a people organization, as a grassroots campaign, they're what did this. And it's unfortunate, the language and the interpretation, but it does offer a hope for future efforts that people really did get together who were directly impacted by the law and organized, and they changed the state constitution. And there's nothing to say that can't be done in other places or for other issues where the public is more supportive of reform than kind of either the perhaps partisan judiciary or an entrenched elite. And so, as dispiriting as it is, there is room, or, we should also acknowledge that there can be some hope and enthusiasm.
Definitely. And Paul, did you have?
I just wanted to say thank you to Michael for that wonderfully encouraging conclusion, and thank you to everybody for allowing us to participate.
Yes.
I'm going to go start reading and think about whether or not we want to go to the Supreme Court with this one or not. I may ask.
Yes, I am so happy we were able to end on that note. Thank you so much, Michael, and thank you all. Enjoy the rest of your day. And as Casey said, we do have a panel at 12:45, so hope to see you there.
Thanks so much, everyone.
Thanks, everyone.
Bye-bye.
Opinion. Thanks, Michael.
I will.
Thank you.